Welcome to U.S. Law Shield Live in Houston, Texas. I'm Sam Malone. Thank you so much for joining us. The great thing about our events, our webinars, you're going to hear from the top independent program attorneys across America from U.S. Law Shield, these experienced professionals on the topic of what you say will be used against you. Now, you're familiar with U.S. Law Shield, right? We're all members. I've been a member for a bunch of years. In fact, there's about 500,000 members across America from coast to coast. And you know when you're a member, you've got that hotline number. If you're involved in a life or death incident, you have access to that 24/7 emergency hotline. Attorney answered by an independent program attorney in your state, but it's for members only. What do? Join. If you're watching this and you're not a member of U.S. Law Shield, go to uslawshield.com and sign up, because when you have that number, when you have that independent program attorney on the line, there's no caps, no hourly limits. You pay zero attorney fees, no deductibles. And an independent program attorney from your state picks up that emergency hotline. Let's get started. Like we say, what you say will be used against you is our topic. Why? Well, anybody who's watched television from, the 60s and 70s has always seen that scene where the police say you have the right to remain silent, so forth and so on. But what will be used against you? What is something that you would say which would just be a bad idea? There's a lot of questions. In fact, that's the number one question that comes in on the non-emergency answered hotline. What sort of things will law enforcement or a prosecutor use against me if I'm arrested for acting in self-defense? Let's go to independent program attorneys in Georgia and in Pennsylvania. Let's go to Matt Kilgo first, who is in Georgia. Matt, thanks for joining us on our webinar. Good to have you aboard. And my hometown of Philadelphia, Mike Dramita standing by. Mikey, how you doing, buddy?
Thanks again for having me, Sam.
Good to have you guys. Listen, let's start in the beginning about the Miranda warning. Mike, we'll start with you in Philadelphia. How did it come about?
Well, this really comes back to the United States Constitution. We get the term Miranda warning because it comes from an old case from the 1960s. And basically, Miranda was a guy who was found guilty of kidnapping and raping. They interrogated the guy after he was picked out of a lineup, and ultimately that was used against him. The confession that was signed was used against him in court. Now, he wasn't advised of his right to counsel, of his right to remain silent, and really his right that if he couldn't afford attorney, one would be provided for him by the state. Ultimately, going up to the United States Supreme Court, they found that his Fifth and Sixth Amendment rights were violated, and ultimately they sent it back down for a new trial. I think it's important for us to understand these rights do come from the Constitution, and maybe Miranda wasn't a good guy, but these rights that come from our Constitution, they're recognized by our founding fathers as important. And if we value the Constitution, if we believe in our Constitution, we need to believe in our Fifth Amendment right to silence and our Sixth Amendment right to an attorney. Our founding fathers didn't intend for our constitutional rights to be only for criminals or only for people who are guilty. They're meant for law-abiding citizens, just like law-abiding gun owners in U.S. Law Shield.
Jump over to Matt Kilgo in Georgia. It sounds simple, Matt. Don't say anything. You have the right to remain silent. But I'm sure it's not that cut and dry in real life.
That's absolutely right, Sam. You know, I tell all of my clients, there's a running joke among criminal defense attorneys. Everyone has a right to remain silent, but few people have the ability. The fact is that so many of us were brought up to respect law enforcement and to do the right things, which means when an officer asks us a question, we are going to answer. And the one thing that I teach in all the seminars that I speak for U.S. Law Shield is no matter what you take away from tonight's seminar, remember, you never have to speak to the police, ever.
Yeah, but let me jump over to Mike. Mike in Philly, cop asks you a question. He'll say, Mike, did you do something? And you say, I have nothing to say. Come on. A lot of people would feel
Respectfully,
guilty.
I want to be cooperative, but I have no intentions of making any statements until I spoke with my attorney. The bottom line is that the Supreme Court has been clear. You have to clearly and unambiguously invoke your right to silence an attorney. And in the aftermath of a critical incident, I'm not saying don't talk to the police at a charity softball game or some kind of police banquet. I'm saying when you're the subject of a criminal investigation after a critical incident, it's important to invoke these rights. Keep in mind that law enforcement officers around the country get 72 hours before they have to make a statement after a critical incident. And there's a good reason for that. You know, there are serious physiological effects involved with a critical incident. You read a book called Grossman on Combat. You'll see all kinds of these things. Heart rate going through the roof. Blood pressure goes through the roof. Time dilation. You immediately become farsighted. You are in no state to be giving an accurate, coherent statement to law enforcement officers at that point in time. So it's important to lawyer up and shut up.
But Matt, and what Mikey's saying is absolutely correct, right? Independent program attorneys from U.S. Law Shield. He's in Pennsylvania. You're in Georgia. But once again, cop asks you a question. Come on, you've been through a very traumatic incident. Now you're not saying anything. This could work against you, yes or no?
Well, your silence will never be used against you, cannot be used against you. So I absolutely agree with everything that Mike has said. Invoke your right to counsel. You can tell a law enforcement officer, look, I'm willing to assist you. I've been through a traumatic experience. I'm a victim. My lawyer's on his way. Let me talk to my lawyer, and then I will talk to you. I will only speak to my attorney. Miranda says that when you invoke that right, it must be scrupulously honored, which means even if you're not under arrest, if you're in a position where you're no longer free to leave, if you are in custody and they begin to ask you questions, they must advise you that you have a Fifth Amendment right to remain silent and a Sixth Amendment right to counsel. And in that scenario, you will very well find, Sam, that a lot of police officers will not ask questions. Even when someone's handcuffed, they will not ask questions because police officers know if they're silent for just a brief period of time, folks will start to talk. And if that's the case, everything you say is admissible and will be used against you. So just don't talk. Tell them, I'm the victim. My lawyer's on his way. I must speak to my attorney first.
Matt Kilgo in Georgia, independent program attorney with U.S. Law Shield, experienced professionals. And like I said, when you're a member and you're involved in a life or death incident, you take out that card, call that attorney-answered emergency hotline 24 hours a day, 7 days a week, 365 days a year. Go online, uslawshield.com. Mike, let me jump to you in Philly. So the cops pull up and I say, oh, look, I'm going to talk to my attorney. I have nothing to say right now. Love you guys, loving cops, but I'm going to be a little quiet. Are there any things that they might look around and see? Now remember, I didn't say anything. I've been involved in a life or death shooting, a self-defense incident, and they see a sticker on my truck. And maybe the sticker says, you know, don't break into this truck, you'll get shot, or I love the NRA, or I heart my AR-15. Mike, are there things that they could see, inanimate objects, that could actually be telling a story or talking?
Certainly that's going to have a practical impact on the way that they view things and the way they move forward in a situation like that. And, you know, there are certain things that I say are not necessarily illegal, but are certainly inadvisable. And having those kinds of stickers, having a dust cover on your AR that says you're effed, or don't run, you'll die tired. Those are certainly things you would never want to get in front of a jury and when you're trying to paint the person as the justified shooter, the person who used deadly force to protect themselves. They want to paint you as someone who couldn't wait to kill somebody, and you're not doing yourself any favors by doing those kinds of things.
Matt, jump in from Georgia. So a sticker on a truck, but don't run, you'll only die tired. Or things like that really work against you, even though you zipped it up. On our topic, what you say will be used against you. What the cops see and prosecutors and law enforcement see could hurt your case.
Absolutely, Sam. And it's not just what they see, it's what they can divine from being where they are if they're in a place they're lawfully entitled to be. The fact that you used a 45 instead of a 22. The fact that you have an NRA sticker on your car. Oh, you're a member of the NRA? Oh, yeah, card carrying for 10 years. Prosecutor can turn that right around and say that you'd wanted to take the life of another person for a decade. As silly as it sounds, somebody out there may try it. If you carry jacketed hollow points in your personal pistol for your home defense because you want the bullet to stay in the bad guy and not go through the wall and hit the kid, I call that a jacketed hollow point. A prosecutor may call it a cop killer bullet. Everything can be used for you or against you. And to the extent that you are able to control those events, stickers on your car, I absolutely agree. There's no reason to broadcast the fact that your car is protected by Smith & Wesson. Not only for this fact, but the fact that your car is more likely the first one to be broken into because bad guys think you have a gun in it. So I'd say stay away from the stickers. Stay away from any statements to anyone. Don't make a witness. Your boyfriend, girlfriend, mother, wife, sister, brother, cousin comes down the stairs. Baby, what happened? And you tell them what happened. You have made a witness. Don't make any witnesses. Don't make any statements.
You're watching U.S. Law Shield live. What you say will be used against you on the topic of what sort of things will law enforcement or a prosecutor use against you. Matt, staying with you. Okay, so bumper stickers, gun cases, T-shirts, something like that. But what about social media? Matt, you're a big 2A guy, and you embrace the Second Amendment, and you have an AR-15 come and take it flag or on your Facebook page. Talk about social media for a second.
Personal opinions do not come without consequence. That's the flip side of the First Amendment that so many people forget. The First Amendment protects our right to say what we want to say, but it does not separate us from the consequence of those. I would say that, yes, one of the very first places prosecutors go now is to a Facebook page. They send their investigators to download your tweets, to look at your Instagram. What's he using? What's he carrying? What's he saying about Black Lives Matter? What's he saying about firearms? Anything that could be used against you to paint you as someone who is willing to take the life of another person. And it could be really anything. Stay off social media. Don't post your innermost thoughts on social media because other people can see that.
Love it. Let me jump over to Philadelphia. Mike Jermita, when it comes to a prosecutor, and they're putting out a subpoena to get things about my life, what are some other things I need to be careful about?
Oh, they could send out just about everything they want. Whether it becomes subject of some kind of a hearing later on down the road is a different story. But you hear all kinds of cases, not only about social media, but about things such as Matt talked about the caliber of the round coming into court. And you see situations where these get in, and many times gun lawyers will look at this and say, well, how did that even get in? Bottom line is the courts have some degree of discretion, and even if they get the decision wrong, you're the one who's going to be stuck on trial and going up to an appeal in these situations. The difference between illegal and inadvisable, they're going to be trying to paint you as the person who couldn't wait to kill somebody. Don't give them anything in their corner. Don't help them out at all. Don't help them make that case against you. Mike
Jermita's in Philly. So, Mike, he's staying with you. It's perfectly advisable, perfectly good idea to tonight go out there with some soap and something and take off the bumper stickers and things like that. You're not being like a weakling. You're not caving in. You're just using good, practical, sound legal advice, correct?
Sometimes discretion is the better part of valor, right? And even if you're doing it as just something that's funny or cute, a joke among your friends, you got to look at risk reward here. Look at the way the streets are these days. Look at the amount of defensive shootings we have within the last couple of months. The phone's been off the hook over here. We have people involved in situations they never wanted to be in their entire life and never thought they would be in throughout their entire life. So understand that just because you think it shouldn't be that way doesn't matter anymore. This is the way it is. We have to deal with reality, and we have to suck it up.
Matt, in Georgia, what realistic steps can I take to mitigate future risks if, gosh forbid, I'm involved or one of the hundreds of thousands of people watching tonight is involved in a life or death incident?
The most important thing I could tell you is have a lawyer. Have someone at your side at a moment's notice who can advise you as the best thing to say and not to say to law enforcement. I can't stress that enough. You've got to have someone who knows the ropes, who knows the jurisdiction, and knows how to help keep you on the right side of the law. Sam, the fact is, and I tell clients this all the time, you may have been completely justified in what you've done. And if you are, Georgia law excuses you from criminal liability. That means you can't be convicted. but it doesn't mean you can't be arrested, and it doesn't mean you can't be charged, and it doesn't mean you can't be prosecuted. Streamline those things that you can. Try and keep your own counsel, as Mike referred to Abraham Lincoln, those better angels of discretion, or you don't say the exact thing the moment that it comes into your mind. Keep your best thoughts to yourself, protect yourself, and be ready to protect yourself with counsel after you've protected yourself.
Matt Kilgo's in Georgia. And finally, Mike in Philadelphia. Also, go back and start scrubbing your social media. But is scrubbing your social media, would prosecutors go, oh, look, Mike, he had this comment up here last week and now it's gone. Will that be used against you? Final thoughts?
Listen, act as quickly as possible and not put those things out there. I want to add to what Matt said because it's so important, not just have an attorney, but have a plan. You don't want to be making a fire plan to how to respond in a fire drills as the house is burning down. You could say one thing in the aftermath that could land you in jail for the rest of your life. And it's a natural thing for somebody to want to vindicate themselves and tell exactly what happened after you had to use deadly force to protect yourself. So have this plan in place and stick to that plan.
And remind everybody, Matt, right before we leave and get to Dr. Hamasfar, when you make that 911 call, things you should say and things you should leave out of the conversation with the dispatcher, Matt.
Tell them who you are. Tell them where you are. Tell them to send that you're the victim. Ask them to send police assistance and hang up the phone. At least in Georgia, it is not a crime to hang up on 911, and everything is being recorded. Who you are, where you are, tell them you've been the victim, ask them to send assistance, hang up that phone, and then put that plan that Mike talked about in place. You know, as they say, the farmer doesn't plant his corn the night before the harvest. Have that plan in place, be ready to enact that plan, call your lawyer.
Matt Kilgo's in Georgia. Mike Jermita is in Pennsylvania, in Philly, my old hometown. When you are a member of U.S. Law Shield and you're involved in a life or death incident and you call that emergency hotline, that attorney answered emergency hotline, you will get an independent program attorney, an experienced professional in your state. If it's Pennsylvania, it could be Mike. If it's Georgia, it could be Matt. Guys, thank you so much for taking the time to join us on our webinar tonight. What you say will be used against you.
Thanks, Sam.
Good to have you aboard. Coming up, we'll get to your questions. Emily Taylor and Richard Hayes, of course, will be answering some of the questions. Got to welcome so many people who are watching us all across America. And remember, if you miss it, it'll start over. And if you're not a member of U.S. Law Shield like I am, what are you waiting for? Go to the website, uslawshield.com. They're the leading legal defense for self-defense program in America. Remember, you pay zero attorney fees. There's no caps. There's no hourly limits. There's no deductibles. Become a member, and you'll have that instant access to those independent program attorneys in your state. Let's go to Dr. Rick Hamasfar. Obviously, the doc has more news about COVID-19 and how you can keep yourself healthy in these tumultuous times.
U.S. Law Shield Emergency Hotline. What's your emergency?
Crime doesn't sleep, and neither do we.
Good evening. Let's talk about the fact that the number of cases is increasing and the spread seems to be increasing. So what can we do to protect ourselves and cut down on the spread? Well, first of all, we have to identify the high-risk groups. And we all know about the problems if you're over 65 or in a nursing home. Those people obviously need to be protected. But did you know that it does not matter how old you are, you could be any age, if you have any of these medical conditions, you are in the same high-risk group as an elderly person. So identify these people and let's protect them, use masks, and try to keep them from getting sick. Now recently, the CDC released another list of medical conditions, and these are medical conditions that put you at a moderate risk. So it's increased, but not as bad as the elderly or the first group that we talked about. So let's identify these people and take the precautions to protect them also. And how do we do that? Well, we do that with social distancing, which went by the wayside with all the protesting, washing hands, and mask wear. But what no one talks about is that there are different types of masks. Watch the video I did several weeks ago and learn about the different types of masks. But some are good, some are bad, some give you a false sense of security and really don't do anything. This is an N95 mask that has an exhaust port, and I see a lot of these being worn around. The problem with this mask is that when you breathe out, you are breathing out unfiltered air. So what does that mean? If you're in a crowd, you're not protecting anybody that you're breathing on. If you're an asymptomatic carrier and you're around people that are in a high risk group or moderate risk group, you are breathing a virus out on them. So know the type of mask that you're wearing, because you want to use a mask that protects you and also protects the people that are around you. And if we can do that, then hopefully we should be able to cut down on the risk of spread and cut down on the risk of disease. So be safe, be healthy. Thank you.
As a U.S. Law Shield member, you already enjoy the best coverage in America. And you can strengthen that protection through our most popular add-on, multi-state coverage. Multi-state extends the service you already enjoy in your home state to protect you in all 50 states, Washington, D.C., and Puerto Rico when you're traveling. And the best part, this peace of mind can be yours for just $2.95 a month. So log in or call us to add multi-state coverage to your Law Shield membership today.
Thanks, Doc. Now let's get to your question that you sent in. Of course, we go to independent program attorneys in Texas, too, for the price of one. Emily Taylor joins us. Emily, welcome to our Coast to Coast broadcast tonight, U.S. Law Shield Live.
Thanks, Sam. How are you?
Fantastic. And of course, devilishly handsome Richard Hayes. How you doing, buddy?
Doing good. Always great to talk with you, Sam.
The Jerry and Elaine of Q&A for Law Shield. Last time it was Ross and Rachel.
I'll take it.
Here we go. The topic, of course, tonight is what you say will be used against you. Both of these are just not just independent program attorneys, experienced professionals, but prosecutors. So they bring both sides to the table. Emily, let's go to a question sent in by Peter M. With hyper scrutiny that the media is putting on every act of self-defense, is an impartial jury trial even possible nowadays? Emily Taylor.
Oh, it's really rough because not only do we have the issue of media coverage before your trial, which is more and more common with self-defense crimes these days. We also have the issue of having non-gun people on your jury, which makes people very impartial. We also, believe it or not, we've actually had problems with gun people on juries before, because we as gun people, as 2A advocates, are very specific about how we know in our brains we would handle an encounter. And when someone has an encounter that deviates from that, I mean, gosh, we've had people who are, LTC holders here in Texas who carry regularly who say, I wouldn't have shot yet. And they can be some of the most critical. Keeping yourself out of a jury trial is one of the most important things you can do.
Richard Hayes, jump in from the former prosecutor's point of view, like Emily was saying. Can you even get an impartial jury today when so many news stories today in 2020, unlike, let's say, 1990, we see every act of self-defense out there? What do you say?
Yeah, with everyone's actions being under a microscope, everyone has cell phone cameras, everyone's recording everything. Things are hitting the news cycle and traveling around the world before things make it to the courtroom. And so getting a jury and panel that doesn't have an opinion on the subject is difficult. On top of that, let's say that, you don't even have somebody who has personal knowledge. Those people aren't allowed to sit on the jury and judge somebody if they witnessed it or if they have personal knowledge about the facts. But there's some bleed over, with headlines and people posting on social media that will reach every single juror, and we see that happening more frequently.
Gosh, that is brutal. Staying with you, Richard Hayes, former prosecutor, you were down in Galveston County, which is a county south of us in Harris County in Houston. This is from Jim S. Interesting question. I don't know the answer to this. We're going to you. Can I tell a police officer information that's, quote, off the record? And I'm doing air quotes with my fingers. Richard Hayes.
Yeah, I mean, you might see that in a movie where a detective, looks around, turns off the tape recorder, and is like, all right, between us, what's going on? What you don't actually see is there's another camera recording you in the corner of the room. So while they may have turned off the tape recorder sitting in front of you, your statement's still going to be recorded. There's nothing off the record. And even if it was off the record, a police officer could just testify about what you said. Let's say you're confident that you're not being recorded. Well, they're going to bring those statements into search warrants. They're going to bring those statements into grand jury presentations and maybe even a trial against you. So there's no off the record.
But Emily, I've seen it on TV. It must be true. Sarge, this is off the record. And you kind of look to your left, look to your right, and say something.
Yeah, one of the most tried and true police tools for getting people to say things that are going to hurt them later are sort of the friendly act, right? So, hey, I know that you were scared. I know you were trying to do the right thing. I'm coming to you as a friend here. This is off the record. Just talk to me a little bit. Bear in mind, not only are A, the police allowed to lie to you, but B, they know as well as the rest of us that you catch more flies with honey, right? So they are going to use that friendship as a tool. And it's a particularly effective tool because you have just had one of the worst moments, probably the worst moment of your entire life. And you're going to be looking for a friend. Find that friend in your attorney. Spill your guts to us, not to the police officer.
Emily Taylor, Richard Hayes, independent program attorneys with U.S. Law Shield. Staying with Emily, and then we'll also jump over to Richard. William C. sends in his question. If you could only tell me one thing to never say to the arresting officer, Emily, we'll go to you first. What would it be?
William, I have way more than one thing, but I'll try to keep it to just one or two here. One of the most important things not to say, and it's something that good people want to say, you have just shot someone. No one wants to do that. I mean, gosh, you step on someone's foot and you apologize. People find themselves saying, I'm sorry. You can hear people saying it on the 911 call. They might say it in front of the police. And that's a natural human reaction to say, I'm sorry. But in the legal world, we call that consciousness of guilt. And they're going to use that to say, you knew that you did something wrong, or else why were you apologizing for it?
So even if you're a down-to-earth, God-fearing, America-loving patriot, and you feel the need to go, I'm sorry, Emily, that could be used against you?
Absolutely. Bite your tongue. I get it. You have hurt someone. Granted, they did something to hurt you first, but you're a good person and you didn't want to shoot someone. You didn't want to hurt someone. It is natural to say, oh, I'm sorry. Don't do it. It will be used against you.
Richard Hayes, continue the conversation on that question from William C. If there's one thing you would tell people to never say to an arresting officer, what would it be?
Well, I'll say to William, there's so many things that you shouldn't say. The list of what you should say is what you should focus on. Because I can think of a million things you shouldn't say to the cops. He had it coming. He made me do it. I'm sorry, just like Emily said. Things you can focus on all the things you shouldn't say, but what you should focus on is what you should say. I invoke my right to an attorney. I want to help you, but I want my attorney present before I talk to you. I invoke my right to remain silent and then remaining silent. There's so many things. You never know how these things are going to be twisted. I had a client, this is a real story, who had a DVR and acted in self-defense, completely justified, captured on video, clear as day. And when he tried to download it for the police, he accidentally formatted it instead of, and the cops viewed it beforehand, so they saw that it exonerated him. But he accidentally formatted it. It was a brand new system. He didn't know how it worked. And they are looking around his house. They see he has some gadgets. They see he has a drone. They see he has some things around. And they say, oh, wow, you're pretty tech savvy, huh? Oh, they're just probing him. Wow, that's a pretty fancy computer setup you got there. And so you could just see it. And thankfully we were there. But you could just see them laying the groundwork for saying, hey, look, this guy tampered with physical evidence. And while those statements sound so innocent, you never know how they're going to come back and bite you. So don't focus on what you should say. Focus on what you should say. I invoke my right to remain silent. I invoke my right to an attorney.
Love it. Richard Hayes, independent program attorney. He's in Texas. Emily Taylor is an independent program attorney in Texas. If you're a member of U.S. Law Shield and you happen to be in Texas, if you're involved in a life or death incident, you'd be getting in touch with these attorneys, because when you call that 24/7 emergency attorney answered hotline, you get an attorney in your state. Let me get back to Emily. And Ed and the initial D sent this one in. I know we've covered it, but it's essential, because after all, our topic is what you say will be used against you. What is the bare minimum, Emily, that I should say to a 911 operator after a self-defense shooting?
Absolutely. We cannot talk about this enough. You must give your name, your location, what services you need. I always recommend you ask for police and an ambulance. And you need to tell them what you're wearing so they can identify you as the good guy. And you need to go ahead and start that self-defense claim, but in the narrowest way possible. So you don't want to say, he came at me and he tried to punch me and then I unholstered my pistol, I fired 6 shots. Far too much information. You never know what you remember, what you misremember, or if that's not advisable based on the situation. Your attorney will tell you what to say or not to say. But I was attacked. I had to defend myself. That's enough. I was the victim of a home invasion. That's enough. So those very small pieces of information are crucial, but that is all you should say, period, end of story. We cannot talk about this enough times.
Yeah, but gosh forbid an event like this happens, or if you've ever been in an auto accident, you kind of lose control of the mouth sometimes. I can imagine the shooting is 100 times worse. So, Emily, I could see where people would be, have trouble closing the gums.
Absolutely. You just have to train yourself now. In fact, I recommend, as silly as it seems, make practice calls. Don't actually call 911 in practice, but pick up your cell phone, call your wife, call your kids, and have them play act it with you so that you can practice just those brief pieces of information. Hopefully a little bit of that muscle memory will take over in crisis.
You're watching U.S. Law Shield's live webinar. The topic, what you say will be used against you. Independent program attorneys Emily Taylor and Richard Hayes on screen. Richard, let me go to this question from Joseph A. And this is good because Emily had just said you give as little info as possible, keep it to a minimum. But what is the best way to project a cooperative demeanor, but still insist on speaking to representation before answering questions?
Well, and this is what I tell my clients to say. And remember, that 911 call is recorded. When the initial officer shows up on scene, he's wearing a body-worn camera or a microphone attached to his in-car video. That's recorded. Everything's recorded. And so we want to keep our statements as short and to the point as humanly possible. Let's say if you've had time to speak to an attorney, then you'll have your game plan right then and there. But if you haven't had time to talk to an attorney, keeping the statement short, sweet, to the point. I want to help you as much as I can, but I don't answer questions without an attorney present. And they might say, why don't you answer your questions? Well, I don't answer questions without an attorney present. The loop fills itself in. And it's so important because you never know how these things are going to be used against you. So projecting that calm demeanor, I want to help as much as I can, but I don't talk to the police without an attorney present. And the police should know this. Mike talked about it. They get time to cool down. They get time to review their cameras. They get time to review the surveillance. They get to talk to everybody else, get their story straight. Unfortunately, we're not afforded that same privilege, but you gotta push through. Our instinct is to help. Somebody asks a question, we want an answer. We want to help and answer it for them. But you just have to. I can't answer questions without an attorney present. If you've spoken to your lawyer at that point, you'll have your game plan, follow that game plan. But if you do nothing else but say, I don't want to talk until my lawyer is here, that will really serve you well.
Emily Taylor, let me get to Chester M's question. If I don't give the police a statement at the scene, will it make me look more guilty later if I should be forced to go to trial? Because they'll go, well, we talked to Richard Hayes and he wouldn't talk to us at the scene. Does it make you look more guilty if you have to go to trial?
Yeah, that's a really insightful question from Chester, and I love it because are there instances where that could be true? Absolutely. That's why, for people who are U.S. Law Shield members, getting your attorney on the phone immediately, right? Because, Richard and I and the rest of our law firm for Texas, there's no switchboard. We answer that phone immediately. That's why it's so important, because we can get that initial statement prepared so you have something ready. Very brief statements, but there is something ready when the police arrive, and then your attorneys are on the way if there's that body on the ground. If you haven't thought to call the hotline, if you didn't get a chance, if you didn't have your phone on you for some reason, whatever the situation may be, it is way better to fight the fight of he didn't say anything, that means he's a bad guy, than it is to fight the fight of he said the wrong things. So, ideally, yes, you have some statements ready when they get there and you can get rolling. If you don't have that statement ready, reviewed by an attorney, have discussed it over with us, it is far better to look guilty by not saying anything than it is to say the wrong things and have that used against you. Because, like Richard put it best before, the things that you should not say or the things you could say that conflict with the physical evidence there are countless things. It is not worth the risk.
Man, this is scary stuff. Emily Taylor, you're watching U.S. Law Shield, our live event. I'm Sam Malone in Houston, Texas. We're going through your questions. This is a good one for Richard Hayes, who's an independent program attorney, U.S. Law Shield in Texas. Jose S. wants to know, can statements I make before being Mirandized also be used against me? Richard Hayes.
Yes, absolutely. And so, this is something you see in movies again, where it's kind of a misnomer. When Miranda kicks in, or hey, they didn't read my rights, they got to throw the charges out. Most of that stuff that you see on TV is kind of baloney when it comes to that. So Miranda relates to two things: statements that you make when you're in custody and being interrogated. So if you're missing one of those two key components, then Miranda doesn't apply. So a police officer walks up to you, hey, nice weather, what's your name? What are you doing here? If you're just volunteering information, well, you're not in custody. He's interrogating you maybe, but you're not in custody. So all of these statements can be used against you. change the scenario a little bit. Let's say you're in custody, but they're not interrogating you. Let's say you're sitting in the back of a cop car and you're just saying, man, he had it coming. I told him this was going to happen. I'm sorry. Well, if they're not interrogating you and you're just kind of running your mouth, that information can be used against you too. So Miranda only applies to in custody statements when you're being interrogated. Anything else, those statements can be used against you, including statements you make before they arrest you.
Man, America. First of all, do you know why there's 500,000 members like myself of U.S. Law Shield? Do you see why it's so essential to have that 24/7 access to the independent program attorneys, the experienced professionals who pick up that hotline from your state? USLawShield.com. Remember, they're the leading legal defense for self-defense program in America. You defend your life, they'll defend your liberty. Let me get back to Emily Taylor. We're on fire. Let's see. Scott K. asks, I didn't know this. Will I be asked to give law enforcement officer the weapon that I use? Will he say, Sam, hand over your blank? Walk us through that, Emily.
Almost every time, yes. That weapon is physical evidence. They can confiscate it. They are going to, they're going to run ballistics on it. They're going to maybe let it sit in a property room until it rusts out. But yes, they are almost every time going to get it from you. Let's say we have this situation in St. Louis right now. Let's say on the scene, maybe there's no arrest made. Maybe they aren't investigating a criminal act occurring, but then something happens down the road and either more evidence comes to light as part of their investigation, maybe there's political pressure, whatever it happens to be, then you are going to see a search warrant come through for those instrumentalities of the potential criminal act. So unfortunately, the answer is yes. And the really sad follow-up to that, because this happens a lot, is we have people say, look, I got into a self-defense incident. It was a year ago. They've had my gun. They're not charging me. They say they're not going to give it back. Unfortunately, the government can hold that evidence for the entire statute of limitations of the crime. So there are people who go years without their, maybe it's a treasured family heirloom, maybe it's their favorite carry weapon, maybe it's the only weapon they own. But that is another, essential abuse from my perspective that the government is allowed to enact against you once they have decided that they're investigating you for a criminal act, which really was your self-defense incident.
And you mentioned St. Louis. I saw they came and took the AR-15 from the household. What is there a procedure, real quick, Emily, to get it back? Is there a Form 5572-9er that I can fill out? Do I call law enforcement? Do I call the district attorney's office and go, hey, that's gun belonged to, my pa who's in World War II. It's got a lot of meaning. Can I have it back? What can I do to get it back?
Oh boy, that is a choose your own adventure of crazy bureaucratic red tape. If they are not going to charge you with an offense, they should release it, but they don't have to until the statute of limitations has run. Now, once you are legally entitled to get that weapon back, sometimes they're still difficult. Now, sometimes at that point, you can just go down to the police station, call them up, say, you're holding my weapon. I hope it's still functional from being in your property room for 2 years, but I'd like it back. Sometimes a little bit harder. Richard and I have filed countless motions with the courts to ultimately get judges to order police departments to return those weapons. It can come to that. Keep in mind, if you are convicted of a criminal offense, very likely they're going to destroy your gun. It is forfeited to the state. So we're only talking about instances in which you are either never charged or not convicted.
Wow, this is good stuff. This is why you need independent program attorneys, and this is why you need that membership to U.S. Law Shield. One more real quick as we're watching the clock. Thomas E. sent in this question. Richard Hayes, is there any info that we're required to give to the arresting officer before speaking to our attorney?
So it's going to depend on your state, and every state's going to be different. But most states do have some form of failure to identify law on the books, which basically says, hey, if you're in custody, you're required to give us your name, date of birth, and your current residence. So most states have a law like that. You have to check your specific law. That's the case here in Texas. If they've arrested you, you got to give them your name, date of birth, and address. Those are the only three things you're required to give in Texas if you've been arrested. Apart from, hey, I'm going to talk to my lawyer, I'm not going to talk to you until my lawyer's here. That's what you got to do here in Texas. Most states have something similar. You need to talk to a lawyer in your state. If you find yourself in that situation, hopefully you've already talked to a lawyer. At that point, you've called the hotline, you've gotten advised that question, what do I need to tell the cops? And I anticipate it's going to be those three pieces of information, but the only way to know is to talk to a lawyer from your state.
Wow, this is a lot, folks. The great thing about our webinar, our U.S. Law Shield Live, is you watch it from the beginning a couple of times. We have learned a lot of great content. Segment 1 with Mike and Matt, Dr. Hemisfar, and of course, segment 3 with Emily and Richard. Emily Taylor, as always, longtime friend, thank you for joining us on our U.S. Law Shield Live.
Thank you, Sam.
And Richard Hayes, as always, you're a great source of knowledge. The two of y'all are a fantastic team of 2A Info. Thank you, Mr. Hayes.
Anytime, Sam.
Well, we've learned a lot in our topic, what you say will be used against you. The most important thing, if you're watching and you're not a member, hurry up, go online right now. uslawshield.com, legal defense for self-defense. They have their emergency hotline. It's attorney answered. And when you're a member, you'll get the number. It's for members only. Number's on the back of the card. Okay? You pay 0 attorney's fees. There's no caps, no hourly limits, no deductibles. You'll get the experienced professionals, these independent program attorneys in your state. So if you're in Georgia, you get Matt. You could get Matt if you're in Pennsylvania. You could get Mike in Texas, Emily, or Richard. Go online right now and join at uslawshield.com. Thank you for joining us on our U.S. Law Shield Live from Houston, Texas. I'm Sam Malone. See.